want to start the stream and see what's happening, if anything. I'm never quite sure if anything is actually happening.
She can't hear me because I'm unmute. Hey, Debbie. How are you?
Hey, Jeff.
Hi. I was talking to you, but I was muted.
Oh my goodness. I'm sure what you said was so important.
I'm gonna jump out of the Zoom.
Yeah.
Sorry, I was on a Zoom call too. Okay.
I think this is the second time I've ever done one of these, the audio thing on LinkedIn.
Yeah, there's only like 300 or several hundred people that can do the audio LinkedIn thing so far. Somehow I got into the elite group.
Good. Excellent.
Jeff,
You like it?
Jeff is special.
Yeah, it's pretty cool. So
how do you record it?
You can't record it, at least through LinkedIn. So we do a separate recording. We're just recording in the background.
Yeah.
How do you? What app do you use to do it?
OBS.
I'm using Audacity.
Okay. Got it.
Yeah.
That makes sense, actually. Okay.
Yeah, and I'm using.
We've actually got an audio engineer listening in. He's going to help us make it better because it sort of sucks right now.
Got it.
But yeah, we're going to start turning them into podcasts because we want a wider audience for this stuff. So
yeah, that'd be great. So you decided how you're going to launch your podcast or anything? Yeah.
No, not really. We're still figuring it out.
Well, let me know. I can give you some pointers. I have a team here. We produce, in addition to my podcast, we produce other people's podcasts.
Yeah, that'd be great. All right. Well, we're at the top of the hour. I'm going to go live here and do a little introductions and stuff, and then we'll pull you on board. I'm going to do probably a few minute introduction of the topic before we bring you up. Okay. Well,
Okay.
you're already on board, but before I introduce you.
Okay. I'll just hang here.
All right. Yeah. Okay. I'm going live.
Hey, actually, we are already live on YouTube.
All right. Okay.
I'll have to.
And we are live. Hello, everyone. Welcome to Your Bytes, Your Rights with Chris and Jeff. And welcome to episode 9. We're talking about data scraping and the LinkedIn versus HiQ decision. Hope everyone's doing well today. I'll give a couple minutes, a minute or so for folks to start loading in. Looks like we've got some people here listening. Hope everyone's having a great day. I see Chris is here. Chris, I think you're going to be a speaker, so we can pull you on board here. If you want to come, if you want to give me a little ask to speak, I can pull you on stage. I think we're going to have Debbie Reynolds talk first, so we don't have to bring you up immediately. But as soon as you give me the say so, I can pull you up on stage. And I'm going to do a little introduction to the topic here before we start. There we go, pulling you up now. Okay, so let's talk a little bit about this subject. Where is my notes here? 1 second.
You got notes now, huh? Wow.
I've got notes. I actually wrote some stuff up here.
We are getting fancy. And actually, for the first time, we republished what we're talking about on ybyr.news. So I'll try to update things in real time on there.
Yeah. Oh, hey, before we start, I want to make sure everybody knows, since there is no way to record this through the LinkedIn Live audio settings, but we are recording this in the background. So if you don't want to be recorded, don't say anything or leave. But we are recording this. We are going to turn this into a podcast, so we get a wider audience. So just so you know what's going on here. Being sort of data privacy focused, we want to make sure everybody understands that this is going to be recorded. So this is about data scraping, and it's about HiQ, a people analytics company that scraped a bunch of data from LinkedIn your data and my data, because we're on LinkedIn, right? And LinkedIn put that data out there on our profiles. I gave LinkedIn the data, not HiQ. LinkedIn told HiQ via terms of service that they could not take this data. LinkedIn also sent them a cease and desist order. Avishai Osterin said in a post on LinkedIn a couple days ago, if I have furniture on my front lawn that isn't under lock and key, can someone just use it? Of course not. That's called stealing. And sure, I wouldn't claim that I have an expectation of privacy preventing people from looking at my lawn furniture, but the court in this decision is effectively saying, go ahead, have a seat, let me know if it's comfortable. That's a pretty interesting perspective on this decision. And that's one side of the story. On the other side of the story, though, is the data that's just sitting there. There are no gates. There are no logins required to get to it. It's publicly available. Can LinkedIn really own that data? If it's personal data, can LinkedIn ever own it, right? So if that's the case, why can't I scrape it? Why can't HiQ scrape it? Isn't this really just giving people more options in the market, maybe even help them find jobs, make connections? Can LinkedIn allow some people to scrape their data and not other people? Let's look at the law that's being applied here. This is about the CFAA, or the Computer Fraud and Abuse Act, and it's controversial. It's sort of a data privacy law, but one originally aimed at hackers. It's really one of the first U.S. federal anti-hacking laws. And it says, to summarize, whoever intentionally accesses a computer without authorization or exceeds the authorized access and thereby obtains information from any protected computer, if the conduct involves interstate or foreign communication, shall be punished. It was really designed to prosecute hackers, but extended to apply to civil cases so that corporations could prosecute civil cases. But these definitions have caused issues with the without authorization or exceeds authorized access, particularly that phrase there. And in a recent SCOTUS decision called Van Buren, there was a 6-3 majority decision. The court found that the CFAA does not apply to situations where a person has authorization to access information for work purposes, for instance, but then goes beyond that access for improper purposes. That case was a little bit different, but it essentially sort of limits the scope of what the Computer Fraud and Abuse Act applies to. And now that court case has been essentially used to sort of say that, hey, you can pretty much scrape whatever you want, and the CFAA is not going to apply. Omar Tene, who's a privacy lawyer, used to work for the IAPP and now works for, I think, a big law firm, just published a blog post a couple hours ago on the IAPP blog. And he asks a question, sort of at the end of that blog post, really is asking, what are we really expecting of these laws and these judges? Are they supposed to be optimizing for data privacy, for publicly available information, for competitive landscape, for free speech? Because all of these different things that we want to have in our civil society are at odds with each other. It's not just one thing that we need to accomplish here, right? Certainly this law, this decision, right, was not good for data privacy, but was it good maybe for competition or for free speech or for public information? Lots of different things to consider. So I'd like to get the take of Debbie Reynolds after I say quick hello here to Chris. Chris, what's your take on this before we bring Debbie up?
Well, actually, so I was one of the first, 1,000 users on LinkedIn. And if you haven't been on LinkedIn that long, they actually used to have an API. So you actually were able to sync the data that you had access to to other systems. So I used to sync it with my like homemade CRM. I used to be big into playing around with my own CRM systems, and that used to work for some time. And then over the years, LinkedIn made this harder and harder, and eventually kind of removed this entirely. So they kept removing certain data points. But then the other point to that is, if you look at your own settings on LinkedIn, they have very extensive sharing settings. So you can get very, very granular in terms of what you are actually sharing with the platform itself and with people on the platform. So my thought would be, well, this is kind of the dividing line. Ultimately, if I set my profile to, hey, only certain aspects can be even crawled, so to speak, and be seen by people on the platform, then to me that also means no one else outside of their platform should be able to have access to it at all, right? So that seems pretty obvious. But anyway, so my days of teaching privacy laws are about 25 years behind me, so I've been focused more on tech investing, so I'll hand it over to Debbie for her take.
Yeah, Debbie, you want to introduce yourself?
Sure. So I'm Debbie Reynolds. They call me the Data Diva. Anyone can connect with me on LinkedIn. I have many thoughts about this case. I actually have several videos that I covered about the Computer Fraud and Abuse Act, about this LinkedIn HiQ case. Also, at some point, we need to rope in Clearview AI because they're on track to be able to sort of talk about these same issues. I think that this is kind of a calamity, right? Because there are many different issues here that are coming into play. And, from the judge's point of view, even though I think what he did was, very narrow and maybe not thinking about the aspect of things like privacy or individual people's rights. And actually, in my view, in the courts, they've kind of tried to dodge this question. When this case went to the Supreme Court, I don't think they wanted to actually say, well, people don't really have rights in the U.S. To not share stuff. So I think, this ruling, unfortunately, I think is kind of narrow to this particular incident, but people are going to be interpreting it broadly and trying to apply it to almost everything, because there really isn't a foundation in the U.S. about what rights we have outside of kind of a reasonable search and seizure. And then, there's never been an interpretation that I've seen, and please correct me if I'm wrong, about freedom of speech, where freedom of speech covers my ability to not speak, meaning my ability to not share in a situation that's sort of outside of a law enforcement type of context. Also, I think we have a digital literacy problem here in a lot of these court cases where, for example, the Computer Fraud and Abuse Act, it was enacted during the Reagan administration after he saw a movie called War Games. So, at that point, people weren't sort of using computers in the same way. At that point, people weren't even imagining people using computers in this way. And even things about, there's been much talk over the years about even the definition of what's a protected computer. So, in this case, if you're on the internet, is the internet a computer? And if it's publicly on the internet, then that means it's not a protected computer. So I think we're kind of tripping over ourselves trying to figure out how to get some skin in the game on privacy. But I think, and this goes to your post that you made, Jeff, a few days ago about this, there are a lot of players in here, but the absent parties here for me are kind of Congress, because we see in the U.S. with things like, the Privacy Shield invalidation, the Biden administration trying to create maybe executive orders or some other type of way to mend the fence on that without actually having Congress pass laws. Or we're seeing rulings like this where they're basing on things that are sort of outdated and not really relevant to not really explaining technology or explaining data in the way that it should be explained, and really leaving out the individual, where I feel like other jurisdictions, they get it, right? And they're trying to either create agencies, create regulations, and also kind of a foundation for privacy as a fundamental human right in other jurisdictions, where we don't have that here in the US. So there really is nothing to hang on to if you're an individual. So it's like, in some ways, this ruling to me says companies that want to make money off people's data have more rights than individuals whose data they're capturing.
Yeah. Well, certainly there's nothing in that decision that really speaks to the individual rights to personal data. They just ignore that, right?
Absolutely, but I think that's purposeful. I think that was done on purpose, because even I think when this case went to the Supreme Court, I think that was the question that people wanted. One of the questions they wanted asked, right, answered, and they sort of sidestepped that. And so it's kind of been sidestepped 3 times now. So twice by the Ninth Circuit and once by the Supreme Court.
Mm-hmm. That's interesting. Where do you think we go from here? You said that you think this is going to be broadly interpreted, Debbie. Are any courts going to rule on personal data and the human right to the privacy? Where do you think that goes?
The case is happening now, and this has huge implications around the same issue is Clearview AI case in Illinois. So this is a data scraping case as well. I don't know if you guys have been following what Clearview AI has been doing in other jurisdictions, but they have a ruling against them in Australia, France, and the UK. All of those situations, they had to delete data that they had scraped off the internet of individuals. They have a case pending in the US, the BIPA case. People are actually surprised that Clearview AI hasn't settled this yet. They may not get away with it in Illinois because they're basically doing in some way, well, actually, it's actually a bit worse than what Facebook was doing when they settled their BIPA case. So Facebook at least had a relationship, right? A first party relationship with people when they were taking their data, even though they weren't, they settled that case because they weren't proper notice to the individual and sort of disclosure about how that data is going to be used and how long it's going to be retained. Where Clearview AI they're just kind of indiscriminately scraping data of individuals off the internet, and then they're creating these databases of that's being used by law enforcement. So I don't think they're going to get a pass from this on that, but I mean, I think unfortunately this ruling may bode better for them. So maybe the court will say, is legal to scrape data because we think, we agree with the Ninth Circuit's case, but the way that you're using data may sort of run afoul of BIPA. So, at this point, that's kind of the only way I see that play out.
Yeah, and Jeff and I have been using the Facebook biometric settlement ever since it was first reported on. For people who haven't heard about it, Facebook paid a $650 million settlement to the state of Illinois, specifically for using the biometric data of citizens in Illinois, which violated BIPA in that state. And there's another lawsuit that has been filed by Texas for, I believe, the same reason, right, Debbie?
Yeah, I think Texas has filed a lawsuit there too. But I don't see how, even if they scraped the data, how that gets them around the fact that they're using biometric data of people. Do we know, Debbie, if Clearview does get fined under BIPA? I mean, that fine puts them out of business, doesn't it?
It could. Actually, recently, Clearview got they got some investment. I think it was like $30 million, if I'm not mistaken. And the fine that they got in Europe was like $30 million. So they that money, the infusion went to that, but they're still making a lot of money. They're still selling a lot of products. I think I'm literally shocked that they haven't even tried to settle this BIPA case, but that's because they want some court somewhere to affirm that they have a First Amendment right to scrape this data and sort of ignore what they're doing with the data. So I'm concerned the courts will interpret this Ninth Circuit ruling to say just that. So it sort of doesn't matter that what the companies are doing with the data, but because Facebook, I'm sorry, not Facebook, LinkedIn, in some ways isn't considered as holding your biometric data, even though they have like your picture and stuff like that. I think the court will think a little differently about Clearview AI in this Illinois case, and that's only because of the type of data that they collect. So if, let's say, a Clearview AI decided tomorrow, or they should have decided before this case, that we're going to not collect biometric information, they may be in the clear here as a result of this other case. But I think the biometric element sort of makes it a more serious matter.
Yeah. What do we think about the argument that the court made in the HiQ case that terms of service were not enough to keep people out? That you need more than that kind of a gate for publicly available information.
I would say, the issue with terms of service is that the terms of service apply to people who sort of are, have agreed to use LinkedIn, right? So HiQ doesn't have to have a LinkedIn account. They just can vacuum data, however, whatever APIs or whatever they're using to do it. They're really not subject to it in terms of the way the court is thinking, because they don't really need to become a member of LinkedIn or be subject to their own terms of service. So it's fine for companies. We see Microsoft doing the same thing, adding that into their terms of service. It's kind of toothless if the person doesn't need to be a member of your app or your service to be able to grab this data.
Yeah. I sort of wonder, if I can get to that data somehow without logging in, by hook or crook, does that mean it's okay to get to it? You know what I mean?
Yeah.
There's almost all kinds of different ways. Like what if, most people don't realize that a lot of data scraping actually happens not by going to the site, but going to other log files and things, so that you don't actually have to actually go to the actual web page. And there are ways to get to that data without actually having to log in, even if you have to log in normally. So if I go through some other mechanism to get the data that doesn't require me to log in, doesn't that mean that essentially it's okay to grab the data then?
I think that's what people will assume as a result of this. Actually, I just had a call with someone, a company that benefits from this type of activity. They were, it's kind of a high five situation, right? So they're like, yeah, great, we can do this now, right? So I think it gives companies, we're talking a lot about, LinkedIn and HiQ and Clearview AI, but data scraping has been around for decades. If you think about those websites where they say, oh, you want to get a report about someone such and such or whatever, they take whatever information that are in sort of databases that they can access, right? Pull those in, but then they subsidize that with other publicly available information that they can get, whether it's right or wrong. So yeah. I think a lot of those people were kind of nervous about this ruling, but now I think they'll be more emboldened to be able to, continue to sort of vacuum up data like this in the U.S.
Mm-hmm. That's interesting. All right. Do we have any questions for Debbie or thoughts? Anybody else before we give the stage to Chris Mcclellan?
Right, so there's a little React button on the bottom of this little app here. So if you want to ask a question, just use, I guess, the cry emoji. I still can't figure out what is it. Is that a cry emoji?
I think you have to ask to speak. If you hit that button, I can bring you on stage and you can ask a question.
And I think Chris is on mute. Chris Mcclellan is on
Yeah,
mute.
hey everyone. Yeah, I'm just seeing if there's any questions for Debbie.
Go ahead, Chris.
Well, thanks. Yeah, appreciate it, Jeff. So it's good to see everyone, and both in person, live here, and those listening to this on a recorded basis. Debbie, just thanks so much. As some of you contributed to, I posted here on LinkedIn. It all gets very meta and ironic in some ways, but I posted about this issue on LinkedIn, and I copied a lot of people on this call. And thank you so much for contributing to what I think is a really cool debate if you follow the threads of the discussion. And it really opened up some interesting topics, and to the point where I actually converted it into a blog post. Oh, and I should introduce myself. I'm Chris Mcclellan from the Data Collaboration Alliance. We're a nonprofit that's advancing meaningful data ownership and collaborative intelligence. And part of our core thesis is that in order to give end users and organizations or anyone control of the data of which they're the rightful owner, we need to start controlling it. And to control it, we need to seriously rethink and reapproach how we build apps like LinkedIn. And so part of that is just eliminating the data silos and data copies that get exchanged between those silos as the basis of technology. Copies are the enemy of control. That's true for currency and intellectual property, and it's true for data. And that's our sort of our thesis. So that's why I got involved and I posted about it. And so what in that post, which I've linked to here, where you can go to datacollaboration.org and check out, Debbie was kind enough to allow us to embed a YouTube video she recorded a year ago on all this stuff, touching on both of these cases, which provides additional context to this news and echoes a lot of the points she's raised here. And so tip of the hat, Debbie, for being so on point and early as always on these matters and offering really impressive insights and helpful context. So you can catch all that on our blog. I did a little extra research around the topic. You know, it's scraping. Is scraping a really useful, scalable tool for researchers to do good work, or is it a watered down version of personal hacking of personal information? You be the judge. But there's definitely a spectrum there of opinions, and to Debbie's point, the law is pretty clear. It's not taking into account, nor was it designed to, the sort of the personal or human rights element of scraping. And for that, we're going to have to not only rethink, as I said, how we build apps and get control of data, but also the legislation and regulations that give people that right as a human right or a property right or whatever is pick your legal framework. I prefer human right. But some of the stuff I discovered in sort of researching a bit more is, to your point, Jeff, that a lot of scraping happens under the radar, but there are ways to make that more difficult on people. So in that blog post I listed, there links to a Forbes piece from a gentleman who posted about this in 2018 that shows you some tricks you can do just to make it more difficult to people to scrape your web page logs. But also in the LinkedIn thread, the other thing I thought was really interesting is the discussion about what is a copy, and so I wrestle with this all the time, and I think it's a debate that needs to happen, because if our core thesis at the Alliance is that in order to give data owners control, we have to eliminate silos and copies, then we better get to brass tacks about what we mean by a copy, and so there was some questions in that thread that I sort of raised in that blog post, or resurfaced in that blog post, is like, if data is versioned controlled, which happens normally in any database environment, is that a copy? kind of, sure. Is data virtualization a copy when you're basically just, it's a distributed saved query amongst one or multiple databases? Yeah, it's, in the same way as, is a mirror image a copy of you? Kinda. Yeah. On it goes. But I guess, and so there will be a blog post coming, and I'll invite feedback on that from people on this call and others. We really need to get down to what is a copy. And for me, a starting point is it transactional or operational data? And is it identifying data that tells where I am or what I bought and what my credit card, not all copies are made equal, I guess is my point. But we're going to have to sort of have this debate. And I'm hoping that the Data Collaboration Alliance can be one of the forums to have that debate. And I'll just end here and open up to questions. But one thing I would like to invite everyone here to check out at the Data Collaboration Alliance is we're building a community. Now, I'm sort of framing it like a LinkedIn, and Jeff has been a huge part, and Debbie's been helping, and it's really exciting. It's really like a LinkedIn, but not for your professional networking, but data and privacy data, privacy reference data, privacy tools. And one of the things we're going through is thinking about offering the members of this community. Well, first of all, there's a couple of guidelines. Like, we're not doing any third-party data collection, full stop. No Google Analytics, and so that's good. Secondly, we're building it in what's called a zero copy integration environment. That means we can build tons of tools in this for this community without ever copying data, personal or otherwise. That's good, Next, we're trying to create, or we're drafting what I'm calling a data owner bill of rights. So as a Google Doc, and I'll invite Jeff and Christian and Debbie and everyone else to offer comments there, because let's imagine that LinkedIn, hypothetically, or the version of it I'm trying to build, has no copies. Therefore, you can put meaningful controls on the data. So what rights should users have in a application environment? And, so there's some really interesting questions that open up there. Like, if you contribute data to a data set, do you have the right to be forgotten from that data set, even though you willingly contributed information to it? On and on and on and on. So I think for people interested in this topic, it will be an excellent debate to not only let's talk about what is a copy, but also what sort of rights do people really have in a mixed environment that where data ownership is actually possible. So now what? What rights should they have, and how can you balance innovation with the right to personal privacy? And that's going to be really fascinating, and it's going to be a work in progress. Like, we're sort of building the plane as it's taking off, And I invite everyone here to join as a founding member. Again, there's a link at datacollaboration.org. I've talked a lot, but it's an exciting topic, and scraping.
Right.
What can I say about it?
So I want to add a couple of things to what you said. So like from a topology perspective, I think what really should happen to point out to people that when you're on LinkedIn, you're not on the World Wide Web, right? So you're a non-player character in a game called LinkedIn. That's how I would describe that. So you're leaving the World Wide Web, you're on this platform, which by just using the word platform, you should know you're no longer on the World Wide Web. The other part to that is, and that goes back to my days when I was coding websites just using crude HTML. We always had this robots.txt file, and you can still find this on LinkedIn today if you just go to linkedin.com/robots.txt, where you tell spiders and crawlers which folders to visit and which folders not to visit, and so forth. So there's already some rules in place that these particular tools should obey. So the question is just how much is that being respected by then the nation states' enforcement mechanisms? And that's what I'm unclear about. Maybe Debbie knows. But we had an ever-evolving default robots.txt file that we would append to all the websites that we would code manually during those days in the late 90s. Debbie, do you know anything about that, or is that like a black hole? I assume it is. And you're muted, by the way.
You're on mute, Debbie, if you're trying to answer.
I'm sorry. Yeah, I agree. So the problem with robots, TXT, is supposed to be a signal to other people who are accessing data what they can kind of scan. It's kind of like a pinky swear promise, right? They don't have to abide by that, and a lot of companies don't do that. I think as a result of this ruling, they probably definitely won't do that, right? So I think hopefully part of this challenge, and this is part of what Chris is talking about, maybe this is something that needs to be considered, or hopefully people are considering it in kind of the next version of the web, right? Where you're creating more control, less copies, the architecture of the way the internet is, the internet was made for sharing. It wasn't made for security. It wasn't made for sort of, having silos in some ways. So obviously, a company like LinkedIn, like Microsoft, it may take them years to do it, but they have the money and they have the capability to build something where if they don't want to share, it doesn't have to be something in a contract where they say, this is against our terms of service. They could actually create something in the future. I'm hoping Web 3.0 will have to answer some of this, where it will literally be impossible or very difficult for a company that LinkedIn wasn't related to or whatever to scrape their data.
You know what? I think what really comes down to here is that data scraping is not going to go away as long as we have copies of data available, right? If data is sort of flowing freely out there. We have to get to, frankly, where the Europeans have gone, where we start talking about data as data privacy as a human right, and more than that, where we start talking about what are people going to do with the data, particularly when we're talking about personal data, and how are they going to process it? If I step back and sort of look at my career path, I've done a lot of data scraping. Generally, it hasn't been personal data. In fact, rarely has it ever been personal data, but I've done a lot of data scraping. When I was working for Cha-Cha, like 10 years ago, I was creating knowledge graphs. We would buy data, we'd create data, we would scrape data, get data from wherever we could, in a variety of different mechanisms, and some of it was scraping. But it wasn't really personal data because we weren't creating those kinds of knowledge graphs. But I don't see that's really going to go away. But if people are going to grab personal data, they have to have some accountability for what they're going to do with it. And I think that's the missing element here. And I think GDPR has got it right. And I think that most of the US laws haven't got there yet.
Yeah, I like the laws and regulations that really tie things to a purpose. So being able to identify a purpose, right now, people can kind of indiscriminately collect things, right? And that's problematic because, maybe I don't want HiQ to have my data. What rights do I have not to share? And that's kind of the gaping hole that we have in the US with not having a foundation of privacy as a fundamental human right as opposed to a kind of consumer right. And then now, to me, this particular ruling is like a corporation has more rights than the individual. So maybe I should just become a corporation.
Yeah.
So I can duke it out in court with these people. I don't know.
Yeah. So there's another.
This does beg the point. Oh, sorry. Go ahead.
So there's another element that we haven't touched on, is not so much about data privacy, but it's the fact that you're pulling data from that website. So remember, way back when, like 20 years ago, we were crawling Craigslist, and Craigslist specifically sets it so that not even Google is supposed to crawl everything all the time, because it costed them a lot of bandwidth, right? So there's a cost associated to that, to accessing the site. And so if that cost is not like offset with some revenue stream, you could basically call that a DDoS attack if you wanted to, but there's definitely a cost involved in just accessing the site, and then specifically if it's not for the intended purpose why I'm publishing this, right? So that seems to be the more obvious angle for me that I'm surprised that they haven't leaned on very hard, because you can probably quantify this pretty readily as a damage, and then, well, you can say, okay, every day you're doing that, well, we'll charge you XYZ for that and just publish that. Yeah, well, it's okay to do that, but it costs you prohibitively more than what you can potentially make from it. And that seems to be the easy answer and the easy way out for LinkedIn in this particular case.
Yeah.
But Chris,
I also
Chris
think
wanted
that
to say
there's,
something.
we talk about data scraping writ large. There's a lot of value in that, because oftentimes people that put data or have data, there's a small chunk of data over here that one person has, and it's in some crappy format, and another person over here has some data. Maybe they don't even know what it is. Another person over here has some data, and if you can actually grab all that data, scrape it, whatever, get that data. Maybe it's something that you can buy. Maybe it's something that's not even viable, right? But you can get all that data, put it together, and create something new and interesting and exciting. I mean, that's innovation. That's a lot of what drives our economy, right? So data scraping has huge value, right? But it's the processing of personal information that's the problem, not the data scraping itself. At least that's my view.
Yeah, so the other part to that we haven't touched on, and funny enough, the court never mentions that. I mean, LinkedIn is now a subsidiary of Microsoft, right? So for me, I haven't used Outlook, for example, in, I don't know, more than a decade. I don't know if anybody on the call is using that and knows if there's an integration with LinkedIn now, because that would be obviously a very useful implementation to have if I already have a directory of people that I've engaged with that I store locally or on the cloud that I'm accessing through Outlook. Then yes, it would be useful for me if that automatically updated with when someone updates their LinkedIn profile. And there's kind of little apps that do this, some little integration that do that, but the obvious thing would be for Microsoft to offer this as a service within Outlook. So you could look at this from like stealing this particular opportunity in some way. Right?
And who knows, this may be an opportunity for LinkedIn to create, like you said, maybe they have a service like, hey, you don't want your data scraped. It's like, it's like how the phone book, your phone number could be unlisted.
Or join the community we're building at the Data Collaboration Alliance and help vote with your dollar and help build the app of the future that we all want to see, one where the members or the users or even the partners connecting data into the environment have control over it. But I'm not trying to say this is a silver bullet or a panacea, but it's going to be a really interesting challenge for myself and the people on this call to help shape a kind of a LinkedIn where that happens and how it's going to work. It's going to be really interesting and exciting, because at the end of the day, we need to address the issues of data ownership and control within apps. And let's face it, that's where most of this happens. We're going to have to build apps different. And this community we're building at the Data Collaboration Alliance is just a first example of that. But let's hope it's a trend.
Yeah, so maybe tell us a little bit about your implementation. How do you envision this is going to be a browser plugin that controls that, or its own browser, or how do you building that?
Yeah, it's going to be a browser-based experience, and so it's basically a web app that's mobile-friendly. Although big tables of data are a little tricky to manage on a phone, but we're doing things to mitigate that. But the community is all about you. You will log in. We're using Okta as the sign-in manager, so we do need credential management. And so, by using single sign-on, the thesis is that you've already used your email for Gmail or Apple or LinkedIn, even another irony, to use via single sign-on. So we're not collecting anything new. It's not another copy of your email address floating in the world. We're recycling one you've already put out there. So you log in using single sign-on, and then boom, you're in. And if this was a video call, I'd even show you the prototype. But you can log in now as a founding member and sort of kick the tires. Just be a bit patient. But it's a browser-based experience. It's a simple navigation on the left-hand side, and that gives you access to free tools. There's sort of an activity tab that will invite you to collaborate on the data sets that power those tools, and that's pretty cool. There'll be like an events tab, dashboards, and all the things you probably would expect from a data-centric community. And it's all divided up into different domains, and data domains and community group domains. And so data privacy group is the one we're sort of starting with. But we're going to be adding more groups to work on data sets and free tools for areas like sustainability and public health and education. So that's the end goal. And all these data sets. So what we're really building in the back on those data sets is like a bit like a digital brain. We're using a dataware platform in the back end. It doesn't make copies so it's like a no-code platform, you could say, that uses data linking and other capabilities to help us avoid making copies. So you can create data models and APIs without making copies, or no new data silos, no copies. So you can check it out now. It's early, and you'd be a founding member, but you'll see the features are rolling out week on week. And I hope that answers your question, Christian. I'm not sure I did.
Oh, yeah. And for the people that are watching the live stream on YouTube, I showed you a site so people can go there, and we'll put it into the quote unquote show notes.
Yeah, I didn't know we were on YouTube. So yeah. And, maybe I really do. This really is we're called the Data Collaboration Alliance. And so I really do, there's collaboration on the data that powers the free tools and those open data sets, but the governance policies and how it's going to work and who owns what data and how do they control it. These are all questions I think everyone on this call might be pretty fascinated by contributing to how that's all going to work.
Yeah, so Jeff and I have been using this metaphor of the do not call list for all your data for quite some time, right? That should exist. Right? I mean, I think everybody is familiar with that.
There's 1,000 ideas we can.
So one thing I could add, one of the things that I like about the Data Collaboration Alliance model is that, I've been sort of following the whole idea of linked data for a while. Really, I don't know, maybe for 10 or 15 years, this idea of sort of linked data sets has been sort of proliferating out through the world, but there was no way to have sort of control and access of the data. And what the technology sort of behind the Data Collaboration Alliance allows us to do that. So you can still maintain control and have access controls, but yet still build linked data sets. And that's what's intriguing to me. So I don't know if people realize, but like Wikipedia has a bunch of databases on the back end of it. Originally, it was just sort of like free-form data, but there's a thing called DBpedia that has like a bunch of data sets that are linked data on the back end of that, which is really sort of cool. And it's not like we've built that yet, but sort of in the data privacy realm, we're starting to build that, but with access controls. So it's pretty sweet from a data side and from a data privacy side.
Yeah, it's kind of like a Web3 outcome, but without blockchain. But we have projects to see how we can make blockchain and this technology, which is called dataware, interoperate. I think one of the things that's happened in the conversations around Web3, and it's totally fair because the CEO or founder of Ethereum coined the term Web3, there's going to be a lot of technologies involved in the future of web and apps, and it won't be just blockchain. But some of them are whereas decentralized apps are kind of thin on the ground right now. There's not too many you can point to. This LinkedIn, quote unquote, we're building is, if you join us, you'll see it being built before your eyes in a collaborative way, where you actually get to roll up your sleeves and work on the operational data that's powering the thing. And Jeff has been irreplaceable in helping us formulate the foundations of this thing and build a lot of the tools we're going to start with, as has Debbie. And I can't thank them enough. But it's going to be a ride, a really interesting one.
Are you using any of the work that the semantic web community did? We were working back in like 2001 on this FOAF structure, it's an ontology structure for people. And I published at one point in time a complete, semi-complete directory of all US citizens in like 2005. And Google never indexed it because there was kind of this spat going on at the time between HTML5 and the semantic web, so this never took off. So I eventually just took those servers offline, which in hindsight I should have never done. But are you aware of these standards?
The honest answer is it's a big world of data. It's such a and I have to confess. Oh, I've got to run. I'm sorry, I'm late for a meeting.
No
but
worries.
the short answer is no. But that's the whole point. So I got to run. I'm really sorry, but thank you for the time today, and I look forward
catch
to
up
doing
later.
more with everyone on this call.
Great.
Thanks.
Hey, Jim.
Bye.
Hey, the audio in this thing is really bad. Can you hear me?
Yeah, we can hear you.
We can hear you.
Jim, are you using JSON LD for the things you're doing?
Sorry, say that again.
Are you using JSON LD for your linked data?
I'm not sure what Chris has on the back end for the linked data.
Because the whole paradigm we've been working on for years is basically signing linked data with standard PKI, and then using a non-token ledger at this point to create verification and proof using DIDs. Anyway, we've got a lot of stuff built out. I'd love to talk to you in more detail about it.
Yeah, we definitely should talk because it is very possible they are. I don't know the protocols they're using.
The really cool thing that we've just been working with the last month is this thing called HyperCore that lets each party have an immutable log that they can only write to with their own key. And we've built fully decentralized login without requiring any token.
This sounds really interesting. I know that they've been playing around doing some sort of a prototype, doing some kind of an encryption using the Sinchi technology and also Appsio, which is one of the other partners. But they're always looking for new partners to try to essentially embed that kind of security and privacy into the data sets. So I'm sure they'd be very interested in talking, Jim.
Yeah, we're not touching any of that. We're just doing a signed transport layer, although the recipient, you can encode the data or encrypt the data with the recipient's key because you have that. Anyway, one other note, I don't want to take up too much time on the call. IIW is next week in the South Bay, and it's sold out, but if you ping me, I know the people behind it. Kalia, Identity Woman, is behind it. This has been kind of, twice a year meeting about personal data privacy for over a decade now. And it's a great thing to know about and go if you can.
I'll ping you. Thank you.
Okay. Thanks.
Great.
Yeah. So Jim.
What else have we got? Who wants to come on stage? Anybody have questions or comments?
Yeah, maybe just to put a pin on what Jim was referring to, because that was really quick. So that's the Internet Identity Workshop. It's in the Bay. It's an in-person event, I believe.
Yeah. Your audio is a little bit muddled there, Chris. I don't know if you can talk any clearer or more into the speaker.
All right. I think it's bandwidth, and I think it's LinkedIn's fault.
Maybe it is. We've actually got an audio engineer, Ethan, here listening in to try to help us with some of those audio issues. So maybe we can get that better next week.
He needs to troubleshoot LinkedIn at this point in time, I think.
Yeah, I don't know. Yeah, I don't know if he can actually help us with the LinkedIn technology.
So yeah, we might have to find a different platform for this ultimately.
Exactly. Um,
All right. So at some point in time in the near future, I want to do basically like a workshop on best practices, like how to behave online, and then we'll probably invite John from like Ideas Beyond Borders and speak to the things that he is promoting for his constituents. So Ideas Beyond Borders is protecting dissidents under authoritarian regimes who can use digital technologies only sparingly, because they are being targeted with all the powers of the nation states and not with the powers of Facebook to sell you on stuff or not make you vote, but being targeted to disappear. So that gives you always a good perspective. So I will have John on sometime soon to lend us his perspective.
yeah. Okay. I'm not sure that I've got anything more to add on data scraping. Other than,
well, there's a
Danny?
lot more in this 44-page document that the court published. So they actually addressed the robots.txt thing in their judgment, but only kind of as an aside. Yeah, but it's a very surprising outcome as far as I'm concerned. And
Sure.
what I'm wondering is if there was a third party that was influencing this. I don't know. Does anybody know about the case with Hulk Hogan, where someone actually financed Hulk Hogan's lawsuit privately to make a particular case for that? I have the conspiracy suspicion here that this might be what's going on, because indeed that company is not all that well funded. Neither is Clearview, by the way. So they would not be able to withstand a $500 million fine like Facebook did. They'd be out of business. So they really don't have an option to settle.
Yeah.
It's a
Well, that was sort of my point about the fine. I mean, yeah, they don't have any choice but to fight at this point, right?
Yep. I mean, which is good. I mean, we need to set some precedents here, right? But they should pick probably a much juicier target, and we can provide them with a target list.
Yeah.
We should publish that. I mean, at some point in time, we'll publish this literally as a target list, I think. As in, these are the data brokers that shouldn't exist, never should have existed. This is what these people are doing with your data, because by and large, the population doesn't know that, right? I test this on a daily basis to have people guess like how many data points a company has on you and stuff like that, or if they ever heard about this a particular company. I'm sure you're doing the same, and there's just always a blank stare. So people by and large have no idea.
Well, we do know, of course, that the biggest data scrapers are the data brokers, right? And I did revisit my list of data brokers. I was talking to somebody about potentially publishing my data stewardship index, which I talked about to maybe a few of you. I think it was last year when I was playing around with it, and that is it's essentially an index that I created to determine who are the worst data brokers. And it's a number that's generated based upon how many data breaches and how many enforcement actions and how many privacy lawsuits and how strong a law enforcement ties. And it's not just like the number of data breaches, but how severe and how egregious those data breaches might be. So it's essentially trying to figure out who's been like the worst data broker that we have, and assign a number to exactly how bad they are.
Yeah.
Maybe. So I was looking at that list again, and that's sort of a little bit adjacent to this whole idea of data scraping, because a lot of the information that these data brokers have is from scraping it from public sources or grabbing it in other ways.
Yeah, maybe we can publish it on YBYR and create a landing
So sorry,
page for all of
Jeff.
those.
I have to jump to my next call, but thank you guys. I really appreciate it.
Yeah, great having you, Debbie. Appreciate it.
Bye.
Take care. All right. Well, we are wrapping up here. It's at the top of the hour. Any last minute questions, or I think we'll wrap up this session. And appreciate everyone for being here. And this has been session 9 of Your Bytes, Your Rights with Chris and Jeff.
Yeah, and if you guys have any ideas for topics you want to discuss, people that we should feature here, or products for that matter, just email me or Jeff, and we'll publish it in our new channel. We finally got a website online. It's pretty scrappy still, but we'll work on that bit by bit, and then eventually we'll turn this probably into a podcast and make it easier to listen to than our little experiment here on the LinkedIn platform.
Yep.
All right, everybody, have a good weekend, and if you like this type of stuff, join us again next Friday.
Yep. Take care, everyone.